My name is Amber Robinson, and I am the owner of Robinson Law Group. We practice exclusively in the area of family law. I have been doing family law, or I've been a practicing attorney since 2008. Today, I wanted to speak with you about child custody appeals. An appeal is when we have a final decision, not just a decision, but the final decision from the family court judge, and one of the parties does not like that decision. And it's not really just an issue of liking or not liking a decision. Did the judge err when making their decision, or did they abuse their discretion with the facts and the law that were presented to them? Did they abuse their discretion? So it's very important on timing. So you get your final decision, and then it has to be entered as the decision, the judgment. And once that is filed with the court, you have 30 days to file your notice of appeal. If you don't file your notice of appeal within that 30-day time period, you are waiving your right to an appeal. And I want to explain that an appeal is not a do-over. The court, the Supreme Court, the appellate court is not going to rehash everything that was done in your case. They're literally going to look at the briefing done by the attorneys, and they're going to decide whether or not the family court judge abused their discretion or made an error. They really just rely on the briefings. The briefings, it's where we cite to the record, usually the trial. We cite to different times in the trial, the different evidence, and we file what is called fast track custody briefs. We have the ability to do fast tracking when it comes to child custody because these decisions are important and they can really affect the lives of families. And so the Supreme Court allows us to do the fast track that I'm speaking of, and it just basically shortens the process of a regular appeal, because a regular appeal can sometimes take years. Fast tracking can even take a good amount of time, but at least it doesn't take years. And you file your appeal, you file your opening brief, the responding attorney files their response brief, and then the appellate court has the job of looking at the briefs, looking at the record, and seeing if the family court judge, again, erred or abused their discretion. They're not really going to ask for oral argument. It's very rare that they would. They would do so if it were going to be a new area of law where they would be making a new decision, new law that is affecting our child custody law here in Nevada. That's when they would ask for oral argument, but otherwise they are going to decide on the briefing only. They're going to decide, should we uphold the decision of the lower court, or do we need to reverse the decision and have the lower court, the family court judge, hold another trial or make more findings? If you have any questions about the appellate procedure, please feel free to give our office a call, 702-527-2625. And remember that time is of the essence when it comes to the appellate process.